Tonight on Bayou Time, we'll come to you from St. Charles Parish and, of course, at the St. Charles Courthouse behind me. The case, well, the judge heard many attorneys, and we're going to bring you up to speed on the Andrew Robison case, which took place, the hearing took place this afternoon here in St. Charles Parish. I'll be joined by attorney Fred Fondren and also former HTV sportscaster Eric Ritchie. It's all next on Bayou Time.
Deep in the heart of the bayou, we are gathered here tonight. Now it's time for action, 'cause our lives are on the line. Tonight we'll do our very best to break through all the bureaucratic mess. The time has come tonight, 'cause it's Bayou Time. Show what Louisiana's all about.
Now, from the Eugene Foltz Studios in Houma, here's Martin Foltz.
And welcome back, everyone. Martin Foltz here in front of the St. Charles Parish Courthouse. A lot to talk about tonight. We'll be joined by people that know a lot more about legal than I do. Fred Fondren will join us. He's been our legal guru here on this story since it's been breaking. There's a lot to talk about tonight. The hearing today, the temporary restraining order has been extended until October 16th. What does that all mean? We're going to ask Fred that question today. We also heard from David Moyer, the attorney for young Andrew Robison. Also, Eric Ritchie, former HTV sportscaster. He's been covering sports across the state for some time now. He's been following the young Robison kid. We're going to get his opinion on the whole matter. We'll take a short break. When we come back, we'll have weather, and we start our program right here from the courthouse in St. Charles Parish. Don't go away. All right, welcome back. Joining me now is Fred Fondren. And Fred, we've been talking about this for a few weeks now. Behind us was the scene of the ruling by the judge. Now, as a legal person, what did it all mean today?
Well, today, what we had on the docket was the hearing on the temporary restraining order that was issued by the judge, Judge Marcel, against LHSAA. Today was supposed to be the hearing on that, but LHSAA came in and filed what's called exceptions, which is legal documents that say why the case should be dismissed, why it should be moved to a different venue, perhaps East Baton Rouge Parish, and why the cases are improperly accumulated. What that means is that LHSAA has said that they should be sued separately from Hahnville or separately from Vanderbilt and Coach Atwell because it's different causes of action, different allegations against them compared to the other parties, and that those things should be heard in East Baton Rouge. All
right, Dan, a lot of attorneys, of course, in the courtroom today. Vanderbilt and Coach Atwell were represented.
Yes.
And if you don't really know this case, it gets to be pretty confusing. But in speaking to the young player's attorney, it sort of puts him in a tough position because now the weeks are running out. He'll be at week 8, I think, by the time we get any kind of ruling, correct?
That's correct. What the judge did was he set the exceptions that LHSAA filed. He set those for hearing for October the 16th, and he moved the hearing on the preliminary injunction, which would follow the TRO, okay, for the same day. So if the judge would grant the exceptions filed by LHSAA, then there would be no need for a preliminary injunction hearing. If he would deny those exceptions, then they would proceed on October 16th straight to the hearing on the preliminary injunction. But either way, I think it's probably unlikely that Andrew will play before then because the current situation will stay in place until October 16th.
All right, so explain this to me. It seems like the LHSAA, and correct me if I'm wrong because you're the legal guy, but it seems like they're digging in, so to speak. I don't know what was discussed in chamber by all the attorneys and the judge, but the judge is in a situation where he's going, guys, I don't want to be involved in probably high school decisions or whatever. That's the LHSAA. So can we work anything out? You've been in chambers before. What would be the most likely avenue that the judge tried to get before the hearing today?
Well, I believe the first thing that would have happened, there was some speculation on my part, but having been back there before on similar things or other cases, the judge, first of all, probably wanted to get a handle on everybody's understanding of what was set for hearing today. That probably moved on to a discussion of, okay, have all of you discussed it? Is there any way we can resolve either the whole thing or any issues so as to narrow down the scope of the hearing? It appears that that didn't happen. It looks like LHSAA has said, you know, based on what we've seen, we're comfortable with our decision. We're going to go ahead and pursue our exceptions, and if litigation is necessary, we're prepared to do it. That was my interpretation of what I saw today.
Now, it's a tough situation because I would assume that Vanderbilt would want to get this resolved. I know that the Robison family would want to get it resolved. I know that the Hornville side would want it resolved because they probably, to me now, besides the Robison, the player, are in the toughest position because if the coach plays Andrew Robison and then they go to the hearing and it gets back to the LHSAA and a ruling is made, they could probably lose everything. They're not having the greatest year, so what impact that would make maybe takes a little leverage off the table. But nonetheless, when you're thinking about all the players in this game, Hornville really in a tough spot right now.
They are. To some extent, even though they're more to one side, they're kind of caught in the middle of this from the standpoint of until this is resolved, they're kind of a little bit of a hostage in the situation because they've got a player that technically remains eligible to play as a result of a court order, but that court order could go away. And so they play him at their peril at this point, which kind of leads us to where we started off. The hearing is going to be set in week 8. The season will be almost over at that point. So that issue, if the can would get kicked even further down the road or the judge would sustain the exceptions and say that the hearing had to be in East Baton Rouge or some other venue, that would be unlikely to occur and have all these issues resolved before the season was over.
Now let me ask you this, and I want the audience to understand it. If Mr. Moyer, and we're going to roll an interview in a little bit, they had a lot of people from the media here, and they got to talk to Andrew Robison's attorney. And I guess the question that I had posed to Mr. Moyer, can he individually, representing the Robisons, go attempt to negotiate with the Hornville side, or is all this now, because it's tied up in court, does everything need to go through the court system and through the judge, or I guess, I don't know if y'all call it ex parte or whatever they do when they're talking outside of the courtroom. Can he do that?
Well, he can. He can negotiate with LHSAA would be the primary party he'd be negotiating with relative to the TRO and an eventual preliminary injunction, because the lifting of that ruling by LHSAA, which they would have the authority to lift their own ruling at any time, but they're the only ones who can do it. Hornville can't agree to have that done. Vanderbilt can't agree to have it done, and Coach Atwell has nothing to say about it either. So if LHSAA would voluntarily somehow agree to lift their previous ruling and allow him to play, certainly the court would not have any problem with that. Right. This whole thing would go away as far as the TRO was concerned, and the judge would have nothing to hear.
The judge would be going, amen.
That's right. That's right. He'd had no issues to resolve between the Robisons and Hornville and the LHSAA. The only thing remaining would be the rest of the lawsuit, which would probably just play out in due course.
It's quite obvious to me in talking with you over the last few weeks, but just sitting in the courtroom and listening to the legalities that go around. This is not a simple process in high school athletics, is it?
It's not. To the people who go watch the games and everything, what you see is what you get, right? You see a bunch of players on the field, they have a game, but it's pretty clear that what goes on behind the scenes as a coach, as an administrator, is much more complex when you have players transitioning from one school to another. There's a lot to know.
Yeah. So, I mean, if you're strategizing right now, if you're an attorney in this whole arena, seems like to me Vanderbilt's attorney, he just goes back and reports back to Vanderbilt and says, all right, hold on, nothing really for us to do. Hornville and the Robison attorney, they have a lot at stake. LHSAA, they digging in, seems to speak. So strategizing, what happens from this point on?
Well, From the Robison standpoint, their ability to negotiate with LHSAA is going to be balanced by LHSAA's necessity of maintaining its authority. That's what you saw here today. LHSAA is not caving. We saw last Friday, a report that there was some negotiation going on between the LHSAA administrator and the attorney for the Robisons, but apparently once the LHSAA board got wind of that, they said, no, we're protecting our position, we're maintaining our authority, we're ready to litigate this issue. I saw that position reflected in court today. If they wanted to make a deal, they could have done it today. But Vanderbilt certainly has nothing to say about the situation from the standpoint of the TRO. It was their original position. They didn't want Andrew to be disqualified anyway, and LHSAA really didn't seem to take that into consideration.
Yeah, they're their own leg, it seems.
That's correct.
And they have which tells me that LHSAA, even amongst judges, maintains a lot of power.
LHSAA, I think from their perspective, needs to maintain its decision-making authority. If they start going back on decisions, if they start re-examining decisions just because somebody files a lawsuit, I think from their perspective, their ability to govern high school athletics kind of goes away, or at least is substantially eroded, and they're looking to protect that authority to the extent that they have to.
But the two sides to that coin, if their decision is right, then it's maintained across the board. But if they make a contrary decision to what they've done in the past, then it opens the Pandora's box and everybody says, well, you didn't rule like that in New Orleans. You didn't rule like that here. So once again, consistency would be the key.
Yeah, and it puts the trial judge in a very difficult situation. I mean, Judge Marcel is a good judge, but you know, I think most judges would be very hesitant to start trying to get into second-guessing the LHSAA in governing high school athletics or high school football from a courtroom. That is an impossible situation for a judge to be in. The judge simply does not have the information, the expertise to govern high school athletics. That's why the LHSAA exists. So I think that's a very difficult thing for a judge to actually rule on the merits of whether or not Andrew ultimately should be allowed to play. But before any decision like that would be made, I think the season's very likely to be over.
You know, and we were talking with some of the Hornville principals or reps before, and naturally we can't talk about this case because they're all under orders not to talk. Absolutely. So we won't breach that. But you could just sense in their emotion, everybody's ready for this to end. I mean, everybody. Nobody likes this.
I believe that's right. It's not good for anybody involved. It's certainly not good for LHSAA. They've taken substantial criticism for their decisions. I think a lot has come out since their decision, frankly, that probably supports it. Nevertheless, I would think they still are ready to kind of move on from this situation. Certainly, I believe Hornville and Vanderbilt are ready to go. And Coach Atwell, I believe, would probably view it the same way. He's got a team to coach, and I think this has been something that's been difficult not only for him, but for the school and his team as well.
All right. Once again, Fred Fondren, and we're here in St. Charles at the courthouse, and we're going to, once again, after the break, we're going to show you the mini press conference we had outside the courtroom with Mr. Robison's attorney. That's Mr. Moyer, and that'll be coming up. And then after the break, Eric Ritchie. You remember Eric Ritchie from HTV? Well, he's covering a lot of sports, a lot of local sports. We're going to bring him on and get his take on this situation when we come back. Don't go away.
What happened is LHSAA filed some jurisdictional matters, exceptions to dismiss the case jurisdictionally and challenging the venue in the matter. The judge today thought that the jurisdictional issues had to be addressed before we move forward with the hearing on the temporary restraining order. The court extended the temporary restraining order until October 16th, and we're going to deal with the jurisdictional issues between now and then.
Why do you think that they were?
I think it's getting late.
We're running out of time. So at this point, I think absent the arbitration process going forward and being resolved, it's going to be really challenging for him to play by the end of this year.
Does it now put the pressure on maybe Hornville to make a decision whether or not he goes or not? Does it put the ball in their court, so to speak?
Hornville has repeatedly taken the position that they do not want to jeopardize the other students and their ability to play. LHSAA has made it clear that they intend to sanction Hornville if they ultimately win this suit and they play Andrew. So Hornville has taken the position, which I don't blame them for taking, candidly, that they don't want to jeopardize the other students that they have at that school.
Why is the extension for 16 days? Why can't they do that quicker?
The judge wanted to give me ample time to file a response, and the judge has a full docket. This isn't his only case, so he had other cases. We also have other conflicts with other attorneys. Me and the other attorneys also had conflicts. That was just the soonest date that we could get.
What's going through Andrew's mind right now? How is he disappointed?
Of course he's disappointed. He wants to play football. He feels that he didn't do anything wrong. He wants to play football.
You're not surprised at the amount of pushback, though, that you're getting from the LHSAA on this thing, are you?
No, the LHSAA has taken this position with every student athlete. They never bend. And I didn't expect them to act any differently in this case. But we've brought up allegations that haven't been brought up in prior cases. So it's a little bit different, but I didn't expect them to change their legal position at all.
What is the best case scenario at this point in juncture?
Candidly, I think the best case scenario is for the arbitration to go forward, hopefully in the next couple weeks, and the arbitrator sets aside the LHSA ruling. At this point, I think, candidly, that's probably the only thing that we're going to get Andrew on the field.
So Marty, they really have the school system in the box, though. There's not a whole lot they can do, right?
I don't think the school system has a lot of options. The school system is bound by their contract with the LHSA. The school system has to go through arbitration. We're not necessarily bound by arbitration, but we're limited in what we can do. There's nothing we can do to compel the school to play Andrew legally.
All right, welcome back. As promised, Eric Ritchie, former HTV sports anchor, and then we chased Eric all over the world till I had to bear that jump shot on him in Indianapolis. How you doing, Eric?
I'm doing great, Martin. Thanks for having me.
All right, you've been covering this. First of all, for the audience, what are you doing now? I know you do a lot of different facets of high school athletics. What are you doing now?
Yeah, basically I'm still a contracted freelance sportscaster for Cox Sports Television, so I anchor report for them. But as far as my own production company, we do a lot of shows, docuseries, documentaries with high school sports, and riverparishfootball.com. We do some high school sports websites, and we're about to launch a statewide network, but we'll tell you about that later.
All right, good deal. You've been following this case, and I noticed you've been doing a lot of things that are getting a lot of attention. Take us from the beginning, and in your opinion, the ruling today.
Okay.
Where does this bring it in your opinion? How complicated is this issue?
Well, it's complicated, and I'll start with the end as far as the last part of your question. Where it is now is that it's in another delay, and it does not look good for Andrew Robison playing football this season. As far as where this began, Martin, I got a call from several of our buddies that still live down there, and Vandy alums like you are. They said, you got to come down and see this guy. Back in Andrew's sophomore season, Vanderbilt was off to a great start. You got to come down and do a show. We were doing a show at that point called All Access Replay. So we went down there, put the mic on the coach, went behind the scenes with Coach Atwell, and really got to know not only Coach Atwell and his Terriers, but Andrew and his family, and reunited with our old HTV buddies. Lonnie Thibodeau was saying goodbye his last year up in the PA booth. But what I saw from Andrew, besides being an exceptional quarterback who could spin it, but was a great kid. So right away, that he's got all the boxes checked. He's a good quarterback. So obviously, a couple years have passed. I get a call and hear that he could be transferring to Hornville. And, you've obviously talked about the background of this story with his father, Drew, losing his job at Vanderbilt. He wound up at Hornville. I went to go interview right after it became official because immediately I knew that Andrew would be the top quarterback in River Parish football. So I wanted to talk to him. We ended up finding him at an LSU Tulane joint football camp at the Saints practice facility. And we talked to him about the transfer. He had nothing but good things to say about Vanderbilt. And wish the program well. He's very excited about the next chapter. One of his teammates, Jaquan Jackson, who's their star wide receiver now, who's a SMU commit. Jaquan was there. Coach Salta Formaggio was there. So to me, everything was out in the open. I would just assume that this would be what the LHSAA refers to as a bona fide move. Everything to me was out in the open, and everything was moving forward. I did not know there was a problem, Martin, until literally just moments before the jamboree. I had my cousin Chris Ritchie in. I told him, come on, we'll take you to a couple of high school football games, get a taste of River Parish football, and I want to take you over to Hahnville. They got a real good quarterback. And then I noticed Andrew was in his street clothes, wasn't suited up. And Andrew, I just heard like, what's going on? And just the whispers then were maybe some eligibility issues. So the story obviously has snowballed since then. But ultimately, Martin, this comes down to, I personally feel bad for the kid, whether who made a mistake with the move, filling out paperwork, the LHSAA, Vanderbilt, whoever, the parents. Ultimately, the guy who's paying the biggest price is Andrew Robison, because I can't even imagine. I know you played sports in high school. I did the same. When you're a senior in high school, you're at the pinnacle of your athletic career. You want to possibly take that next step to go college ball, and to lose that year, I can't imagine it. And I certainly feel for the young man who walked out of this courtroom with just kind of, he's kept a good approach this whole time. Everything that's gone wrong, he's faced the cameras and kind of said, I still have hope to play, but, time's running out, and I think that's what his lawyers told us today.
But you said he always had something good to say about Vanderbilt, and when he was leaving, I'm just wondering where it all caved in from that point. Where did all the vinegar get thrown in, the spice get thrown in? And we're talking about kids here.
Yeah.
We're not talking about adults. Mm-hmm. The adults seem to be making the mistakes in this case.
Yeah.
But he's still a kid when you think about
it. Yeah, and think about when you're a kid too. And when I was in high school, wasn't a lot of reporters putting microphones or TV cameras in our face. Right. And think about, he's trying to give a politically correct answer. He knows that anytime that you transfer in high school, there's always a fine line that you got to walk. And I'm sure during that interview when I talked to him at the LSU Tulane camp, he wanted to say the right things. Maybe he felt differently, but publicly he said the right things. And to me, there was never an issue. The only time I ever knew that there was the vinegar, as you put it, was at the appeals hearing just a few weeks ago in Baton Rouge, when he, in detail, kind of went through some of the things that he said happened to him once he said that he was going to transfer to Hahnville. So, again, I think, he's trying to say the right things, but, things are coming out as deep as this kid because, you got to think they're desperate. Right. I mean, it's only, week 8. 9 and 10, Hahnville might not even make the playoffs this year. So, when this thing gets continued and they hear it again on October 16th, they've got 3 games left: East St. John, Central Lafourche, and H.L. Bourgeois, and that's it.
Same question I asked Fred Fondren, the attorney. It seems to me the LHSAA, they're digging in. Oh, yeah. You heard it. They're digging in. They're not budging. So they must feel fairly strong in their case if they're digging it. If not, I guarantee you they'd have been in that chamber going, all right, let's make it all go away. Obviously, they feel strong about their case. Would you agree?
Oh, no. I'm sure they feel strongly about their case, and I heard you talk to Fred in the opening segment about they've got a lot of power, and they really do. And I think that was on display, to be honest with you, what we just witnessed in this courtroom here at St. Charles Parish, because not only did they get it continued, they got it continued 16 days. So now that young man's going to, at minimum, miss 2 more games. Yeah. So I think the LHSAA, feels strongly about its case for sure, but also, as we said before, they've got a lot of power.
All right, you've hung around Andrew Robison. Now, I want to reiterate, Robison. Hey, every time I say Robison, somebody calls me and says, it's Robison. Every time I say Robison, somebody says it's Robison. The judge said Robison today. So what do you say?
I thought the judge said Robison.
Well,
I think one of the lawyers said Robison.
Okay. Well,
I think his own lawyer might have said
there's
that.
my point.
But the same thing, like right. The Saints, Alvin Kamara. It's Kamara, and it's Robison.
Right, okay. All right, there you go. So you've been hanging around with Andrew, interviewing him, doing different things for an 18-year-old. Because I know the Vanderbilt players are taking this hard too, and the Hahnville players.
Absolutely, yeah.
But the focus is on one 18-year-old boy.
Yeah. Yep.
Young man, I should say. How's he taking it?
It's very hard, and he has said as much since that since the day when he found out that he wasn't eligible to play in the Jamboree and missed that opener, and then after the appeal to miss one of the greatest rivalries in the state of Louisiana, not to be able to run out of that field and play against Destrehan. He has made no bones about it that it has been difficult. It has been devastating. You know, the whole family has been devastated by this. You know, this is a sports family. Obviously, when they moved from Tennessee, you know, they had a sports background. He was the youngest player, unverified, but the youngest player ever to throw a varsity touchdown. He threw it in 6th grade. He was like 12 years old. They put him in garbage time. He threw a pass, and it's on YouTube, and the guy ran for like an 80-yard touchdown. So this guy, this whole family is all about sports. They're all about football. And there's no question that it's devastated him and the family, but I can't reiterate it enough how mature and well-spoken he has been, his mother has been, his father. I think that the family has handled themselves very well in light of the situation.
But do you think that everybody, including his parents, including Vanderbilt, to be fair, including Hornville, including the LHSAA, would have done everything different had this come up again?
No question.
Same circumstance.
No question. I think it all boils down to, in my opinion, that proverbial bona fide move. Is that a move for athletics? Is this a proper move? Are you following the letter of the law to the T? And I think ultimately what I hope comes out of this, I would love to see Andrew play, obviously, his senior year, but what I hope would happen is that these rules get changed and that maybe that there is wiggle room for a player to not be losing an entire year of eligibility. Let's do 4-6 games. Let's at least let the players get on that field at some point. Pay a price. Maybe the letter of the law wasn't followed to the T, but I think the crime certainly not the punishment not fitting the crime.
But the concurrence form that Vanderbilt had to fill out early, and I say had to fill out because they had to fill it out, or they can get sanctioned, from what I'm told. Doesn't that pit principal against principal?
There's no question. There's no question that this whole, even, you know, Mr. Lumar, the principal at Hahnville High School, played the recording from Vanderbilt's principal. So, yeah, this whole case, Martin, has been finger pointing back and forth. You messed up. No, I messed up. He messed up. Ultimately, it boils down to Andrew's not playing, and it doesn't look like he's going to.
But adults, once again, messed up.
Exactly, which goes back to what I'm saying is let there be some kind of rule change where the kids can still get a play when maybe the parents, maybe both schools, maybe everybody's at fault maybe a little bit, but let's not punish the kid the whole way.
Well, in closing, I would make one suggestion to all coaches. Don Schwab came up with it.
Yes.
All his years of coaching, he never had a controversy at the LHSAA.
Yeah.
He knew the rules.
Yeah.
And he followed the rules. And if it's in the gray area, it ain't happening.
Yeah.
I would suggest all coaches and principals learn the rules.
Yeah, no question. You got to know the rules. And it goes back to the whole wearing the jersey for the photo shoot back in May. And, it's a mess. It really is. And I just hope there's some kind of happy ending for somebody at the end, but it doesn't look like there's going to be.
Eric Ritchie, thanks again. Good to see you again. And helped us out way in the 90s. What was the first year? 91, 92?
92, yeah. South Terrebonne and Thibodeau.
Yeah.
The first year we did the HTV radio phone game of the week, I kept hearing from Don Schwab and yourself, no team from our parish or Lafourche Parish has won a state championship since the 50s. I'm there one year. South Terrebonne wins 4A, Thibodeau wins 5A. And then I said, see you later.
And then I bet all the teams.
The Saints won the division that year, too.
I'd treat them to a steak dinner. If they won.
That's it.
2 teams won. Remember East Park Recreation Center? We had a steak dinner for everybody.
I remember.
Eric Ritchie, thanks for joining us. Appreciate it. We're going to take a short break. We'll be back with more here from St. Charles Courtroom. Don't go away. All right, welcome back. An update this afternoon. Of course, we were in St. Charles Parish. Now we're on the news desk, and joining me again is Fred Fondren. When we talk legal, we go to Fred. All right, so Fred, we discussed everything that happened in the ruling today, but late Friday, a response, exception, and answer by the Louisiana High School Athletic Association to the plaintiff, Andrew Robison, verified petition for temporary restraining order, preliminary injunction, permanent injunction, and petition for damages. We said the other day we heard 25% of this whole deal, which was the Robison side. Now we had 50% because we heard from the LHSAA in these documents, and they attacked the allegations pretty well in these things.
That's right.
We said last week you were only getting part of the story because only the plaintiffs had filed pleadings. LHSAA has now come in and taken its position in the case. And by the way, we now have 100% of the parties relative to the TRO, right? Because the TRO was against LHSAA.
Good point.
And so the LHSAA has filed exceptions or objections to the Robison's ability to even file this lawsuit in this jurisdiction and venue in St. Charles Parish.
All right, so they basically said you filed it in the wrong place.
Correct.
All right, so, and they went into pretty good detail about that also, didn't they?
That's right. LHSAA has taken the position that this case should not have been filed against LHSAA together with the case they filed against Vanderbilt and against Coach Atwell. They take the position, as they've taken in previous cases, that LHSAA needed to be sued in East Baton Rouge Parish. And they take that position in this case as well.
All right, and also we're going to put this entire document, which we're talking about, that's going to be on our webpage and also on Facebook so you can read it, because we have a lot of pages to get through in about 17 more minutes. So I want to jump to another part of this, which was page 2 of 17, a very important document where it says the claimant in this instant matter is asking the honorable court to upset an eligibility ruling that was confirmed and upheld by its executive committee. And let's bring that on the screen if we can. The student at issue, Andrew Robison, it's on page 2 of 17, was ruled ineligible following an investigation that determined that, 1, the plaintiff's parents, Drew and Collier Robison, intentionally falsified the LHSAA residence eligibility form for the purposes of establishing athletic eligibility for their son. They go to Exhibit 1. Let's go to Exhibit 1 right now, if we can pull that up. There you see it, the LHSAA residence eligibility form. Why did they include this form?
Well, as I said last week when we first discussed this, anybody can put whatever they want to in a lawsuit, but the proof is always in the documents. What LHSAA is saying is that in order to try to justify filing this suit, the Robisons made false statements in their pleadings that are contradicted by documents that they filled out themselves. So Exhibit 1 would be the LHSAA residence eligibility form. We discussed this document last week in the context of LHSAA's investigation. LHSAA, as you may recall, in their investigative findings, focused on the fact that the Robisons, Mrs. Robison, said that Andrew's father was coaching at Hahnville. You may recall that the Hahnville AD, when interviewed by the investigator, said, not only is that not correct, but there was no job to be had. He's not working here, and I didn't interview him for a job. LHSAA is seizing upon that, saying, look, this court lacks jurisdiction over this case. LHSAA is a private organization. The previous case law on this does not allow the courts to come in and interfere with private rulings in an organization of which Hahnville is a member, a voluntary member, and they agreed to the rules. Moreover, they're saying that they also said incorrect things in their pleadings based on documents that they themselves filled out.
All right, and I know we have a lot to talk about, but they also, let's bring up Exhibit 2. It's an exhibit that we uncovered here. Between Fred and I went over it last week. There's Exhibit 2 from the Terrebonne Parish Consolidated Government, where they put their name on the fact that we are residents of Terrebonne Parish. The LHSAA used that as Exhibit 2 in their documents, so they must have deemed that pretty important.
They do. And in paragraph 59, page 12 of 17, they actually make allegations of their own. In other words, instead of simply denying the Robisons' allegations, they state affirmatively in paragraph 59, in further response, it is patently false and misleading for this plaintiff to assert that the Robison family did not violate any single provision of LHSAA Rule 1.13, which of course is the residency rule. As the plaintiff has already cited in this document, Rule 1.13 prohibits the existence of dual residency, and it requires that the move made be with the intent that the move into the new home be permanent and the sole residence. You may recall that in the Robisons' lawsuit, they indicated that the address that Mr. Geldner from Vanderbilt said may be a dual residence. In other words, they're still maintaining the home of residence on Lakewood Drive. This Exhibit 2 is LHSAA seizing upon that and saying, look, they accused Vanderbilt of fraud. They said they had no dual residence. They said they didn't violate Rule 1.13, but Exhibit 2 shows that they themselves were saying that as of August the 19th, their residence was 332 Lakewood Drive in Houma, Terrebonne Parish. So they are actually pointing to the documents as we kind of expected that they would.
Now, let me ask you this, because thinking more on that, I called Mr. Roddy LaReal, who is now the director of Terrebonne Parish Recreation. And I said, Roddy, let me ask you a question. Can someone play in Terrebonne Parish in the recreation department if they are from out of town, if they are not a taxpayer of Terrebonne Parish? The short answer to that was yes, they can, but they cannot participate on any all-star teams. So I said, okay, which leads me to a question. If the Robisons were filling out a form for their child to play in Terrebonne Parish, and they say, we are residents of Terrebonne Parish, and they put the address of where they live, why wouldn't they have just said, we live in an apartment in Hornville, and we're not residents of Terrebonne Parish, if indeed you don't have to be a resident of Terrebonne Parish to play in Terrebonne Parish?
That's a good observation. What you're saying basically, I think, is correct. They didn't get anything out of putting that address on the form as far as being eligible to play TPR sports, other than potentially if their son would have made All-Stars, the rules wouldn't allow them to participate in All-Stars unless they were residents of Terrebonne Parish.
And in all fairness, I would love, and as we saw earlier in this program, their attorney did speak to a group, and I made several phone calls to them, just trying to get that side of the story. There may be something to it, but we haven't heard why. So that just hit me as being a little bit odd, you know?
It is, and there could be a number of reasons why they filled out the form the way that they did. They may say, and I'm speculating a little, but a potential defense to this may be, hey, I just got used to filling that address out on anything. I lived there for several years. But certainly it wasn't necessary from a rule standpoint to fill out the form and say that they were living in Terrebonne Parish for their younger son to be eligible to play TPR sports.
But it would have made the world of difference where the LHSAA now uses it as an exhibit, and they go, whoa, here's proof that you had a dual residency. And it also, once again, is you doggone better believe that when we get Vanderbilt's answer to this, they're going to say they filled that out 5 days after the principal, you know, who was accused of fraud by the statement, they filled that out 5 days after that.
Yeah, I think in court, whatever explanation they have for the way that they filled out this document, Exhibit 2, we can only speculate what that'll be.
Right.
But I do think it is difficult to make the case for fraud against Vanderbilt or a faulty investigation against LHSAA when 5 days after the concurrence form went out, they also said that they were living in Terrebonne Parish.
Right. What else did you see in this? You're pretty seasoned at going over these things, and I know we're getting it fairly quickly here. What else is sticking out that you see that the LHSAA fired back, and now we're getting a more clear picture of what actually took place?
So I think when you get by the jurisdiction and venue objections, whether it should be filed at all, whether it should be heard in St. Charles Parish as opposed to East Baton Rouge Parish, when they get into the meat of it, which is the exception of what's called no cause of action, okay, and what that means from a legal standpoint is even if we would accept as true everything you said in your lawsuit, Mr. Robison, it still doesn't amount to anything because you don't have a case, even if we believe everything that you say. And the reason that they take that position is that the courts have ruled, consistent with LHSAA's argument, that in order to have a cause of action, there has to be a violation of either a legal right, a statutory right, or a constitutional right. And what they're saying here is that in Louisiana and in this jurisdiction, there is no legal right, there is no statutory right, there is no constitutional right to participate in high school athletics.
So playing football does not give you a constitutional right?
It does not. There is no, in order to have a cause of action in this arena, you would have to have what's actually categorized as a property right. The courts have not recognized any such right and have, in fact, have dismissed several cases that have alleged it. And so without that right, there is simply an expectation or a privilege, perhaps, to play football, but that's not something that would support a lawsuit.
Okay. Anything else you see that we've seen them play their hand now? Not playing their hand, they're answering the lawsuit. And anything else that sticks out to you that's fairly important?
They are saying also that the lawsuit is premature from LHSAA's perspective because LHSAA's members, which would include Hahnville, has agreed for itself, its coaches, its players, that in the event of a dispute, and in the event that they still dispute the case after the appeal, that the case has to be arbitrated in front of an arbitrator, not by virtue of filing a lawsuit. So, in fact, Hahnville initiated arbitration after the appeal.
So, in other words, they put the cart before the horse.
That's correct. They're saying Hahnville has already followed the procedure to initiate arbitration. The arbitration has been accepted, and they need to proceed and let the arbitration play out before they are allowed to file this lawsuit against LHSAA.
Okay. Today in the courtroom, we saw the LHSAA attorneys. We saw Coach Atwell and Vanderbilt Catholic's attorney in the room. We saw Hahnville's attorney in the room. When you get an answer like this, and this is the LHSAA answer, do the Vanderbilt attorneys and the Hahnville attorneys buy into this, or do they talk to that attorney and say, okay, you made some good points, we joined forces? How does that all work?
Well, there is certainly some alignment between LHSAA, Vanderbilt, Hahnville to some extent. Of course, I think any attorneys involved, any parties involved would be foolish not to look at the position that the other side has taken and give it the consideration it deserves, and at the very least decide how to strategize and how to perhaps combat that position. And when I say alignment, I don't mean that the parties have agreed to an official alignment,
right,
but certainly there's some commonality in the positions, the legal positions between LHSAA, Vanderbilt, to some extent Coach Atwell, and even to some extent Hahnville.
Right. But I mean, they go right after, we in the media can say that we think somebody falsified something, and we better have pretty doggone good proof to go at it. But they're asserting this in the answer back that they falsified documents. So we're getting the firsthand look from the LHSAA. And so now, just like we told everybody, as we get everything trickling in, it changes a little bit. So it depends on where you're at and which side you're on and what you want to believe, but we're getting a different look at it today.
In many cases, in fact, you see it throughout this answer. Most of the answer is just simply denials of the allegations made by the Robisons. But you're right. When they get in here on page 12 in paragraph 59 that we've already discussed, they're not just saying we're denying your allegations. They're going right after them and saying, wait a minute, you falsified documents. You've taken a position in your pleadings that is completely contrary to the documents that you have filled out and signed yourself. And they've in fact said they believe that this is false and misleading on behalf of the Robisons. So they go straight after their allegations and take the position, you probably should have disclosed this to the court in your pleadings.
So let me ask you, let me play the advocate for the Robison side. Say they made an honest mistake which started all these wheels turning. Say that TPCG thing was just an honest mistake. That mistake, can they justify that mistake that undoes everything? Or does a judge look at it and say, what was your action that caused all this to start?
It is completely reasonable, I think, for somebody to come in and say, here's why I filled out that document that way and I simply made a mistake. But when the judge looks at this, he's not going to be looking at that document or any other document in a vacuum. He's going to be looking at the situation overall. And so when you see that document, Exhibit 2, if you read it in light of them making an allegation of fraud against Vanderbilt, then it makes that fraud a difficult allegation to prove. If you look at that allegation and then look at the statements that were made to investigators about where Mr. Robison was working, the statement Mr. Robison made regarding the bona fide change of residence, that they only had a one-year lease and after 1 year, they would consider their options and decide what to do. Remember, a move has to be permanent.
But in Exhibit 2, everything they accused, or seemingly or allegedly accused, the principal of Vanderbilt that he did, they undid it 5 days later by signing a TPCG form.
Yeah, I think the way that I would explain it if I had to say this in court was that the Robisons verified what Mr. Geldner put in the concurrence form when they filled out the form with Terrebonne Parish Consolidated Government for TPR Sports.
All right. Well, Fred, we appreciate it. Anything else in close? Got about a minute left. Anything else you see? And is this everybody falls in line now? You use the word alignment. Do we hear from Vanderbilt next on their answer, or what's the normal?
So Vanderbilt still has time to answer the lawsuit, file its exceptions, file its objections. The court, in fact, indicated that Vanderbilt had gotten an extension of time of 30 days from when the pleadings would otherwise have been due. Vanderbilt would not have as tight a time frame for filing pleadings as LHSAA did because Vanderbilt was not party to the temporary restraining order that required a quick hearing.
Real quick, we got 50 seconds left. I learned today, maybe I'm wrong, the same lawyer is going to represent Coach Atwell that's going to represent Vanderbilt all in one?
Initially, it looks that way. That could change throughout the course of the litigation, but at least initially they'll be represented by the same
And real
attorney.
quick, he's entitled to, so Vanderbilt will take care of his litigation purposes of payments, I guess the way it looks now.
I haven't heard Vanderbilt say that. I suspect that the attorney representing the school and Coach Atwell is probably retained by whatever insurer.
Good point.
Insures the school and its employees.
Once again, Fred, we appreciate you coming on. Very nice job of analyzing in this very tough situation. I'm sure we'll be seeing you in short order.
Anytime, glad to do it.
Thanks again. Once again, Fred Fondra. We'll take a break. We'll be back with more, including sports, right here on Bayou Time.